Feels a bit odd talking to you all when I'm just looking at a screen, but hello all, whoever you are. I'm here to talk about the employment law and HR aspects of the coronavirus job retention scheme. I've been doing a lot of advice on this in the last month. Feels like that's all we've been doing actually for the last month. None of us, and I'm sure I'm not the only one here, that had never heard of furloughing until the 20th of March this year. And since then we've been on a bit of a roller coaster ride in terms of a learning curve. So just as Kieran's outlined already, there's a bit of a health warning with the advice. I can't give individual employment law advice in the course of this seminar, and I would urge you to take independent advice on specific queries, particularly if you've got a complex situation, because it's so new, this scheme, and it is very much evolving on a daily basis. So I'm very happy to give people individual advice in a more formal context, or if you already have your own advisors, I would urge you to speak to them about particular situations. I would also say there's a bit of a health warning in that the guidance that we got on the scheme has been updated 5 times since I last gave this seminar. So it is very much evolving on a daily basis. I also won't really go into the tax and payroll technicalities of the scheme, and I believe there might be some information on that from SIS coming on stream at some point, but I won't be going into the finer detail of that in this afternoon. So as I say, none of us had really heard of furloughing until the 20th of March, when the Chancellor announced that there would be a scheme to try and protect jobs in the current crisis. And what we now have is the Coronavirus Job Retention Scheme, which now applies from the 1st of March 2020. And it was originally going to cover wages until the 31st of May, and it's now been extended to the 30th of June. That was a fairly recent announcement. So that's a maximum of 4 months that employers are going to be able to apply for assistance with staff wages from HMRC. So if we just look at the first slide, the system's been live since the 20th of April, so last Monday it went live, and it didn't collapse, and employers were able to make their claims. While some of the issues are quite complex in relation to furloughing, I understand that actually making a claim is fairly straightforward. So once you've worked out what you're going to input on the online form, it is apparently quite a straightforward process. But I suppose getting to that point can sometimes be a bit more tricky. As I'm sure a lot of you are aware, you get 80% of wages that you can apply for under the scheme, up to a cap of £2,500 a month, which means anyone that earns up to £37,500 is going to be able to get 80% of their wages covered by this scheme. I mentioned the government guidance, and I've put that on the next 2 slides. If we move on to the next one, when I first gave a seminar on this back at the end of March, we didn't have, well, we had the first piece of guidance, a fairly short piece of employer guidance. Now we have a fairly lengthy employer's guidance, we've got employees guidance, we've got a Treasury direction, we've got a step-by-step guide, we've got a calculation guide, which is work out 80% of your employees' wages, it's called. And we've also got a real-time information guide as well. So we're now drowning in guidance, having had none at all. We've now got absolutely tons of the stuff. It's not all consistent with each other either. So don't worry if you read something in one place that doesn't seem to match with what you've read in another, because they're not exactly the same on some things. But we've now got absolutely tons of guidance. One notable difference is the employer's guidance doesn't tell you anything about annual leave and how that operates during furlough, but there is some guidance on that in the employees' guidance. So it's nice that the government decided to tell employees what to do about their holidays, but not employers. So I'll come on to that near the end. I'll cover holidays. So I've put all the web links on the slides there, and as soon as there's a new iteration of the guidance, the website obviously updates the guidance. It's very well written, albeit that some of it doesn't necessarily say exactly the same things. But I'll point out as I go through where you might want to use some of this guidance as you go through and look at your own workforces. So what is furloughing? Well, it's basically a form of leave where your employees remain employed, but they don't do any work for you. You agree a temporary change to the terms and conditions, and you can then go ahead and apply for 80% of their salary from HMRC and up to 3% of their employer pension contributions. Minimum period is 3 weeks. You must furlough someone for at least 3 weeks. Any shorter than that, you won't be eligible. And the maximum period, as I said at the start, is now going to be 4 months, 1st of March to 30th of June. So who does the scheme apply to? Any UK organisation with a bank account and a PAYE system can apply, as long as you were set up by the 19th of March. This was one of the big changes. The cut-off date was the 28th of February, and now it's been changed to the 19th of March. So that does bring a lot more people into scope, and particularly people that were potentially going to be taken on as seasonal workers slightly later in the spring. So they've now been scooped up by the PAYE date moving. So anyone that was on your payroll as at the 19th of March 2020 will be caught. If you made them redundant after that, you can re-employ them and furlough them. So if there were people that you took on before the 19th of March and you then had to let them go, you can re-employ them and then apply to have their wages covered under the scheme. Similarly, because the date changed, if you have anybody that you made redundant after the 28th of February, you can also re-employ them and apply to claim their wages back under the scheme as well. So it's made it a little bit tricky moving the date, but it has brought more people into line. It also applies to fixed term workers. So if anyone's fixed term contract has expired after the 28th of February, or after the 19th of March, you can renew that contract, get them back on the payroll, furlough them and apply to get 80% of their wages back. And certainly there's, again, that where it applies to seasonal workers, that has again meant that it will help a lot more employees and employers who otherwise would have slipped through the net. What about fixed term workers who are whose contracts will expire whilst they're furloughed? Well, it will apply to them as well. So you can renew. So let's say you're furloughing and someone's due to end on the 5th of May, for instance. You can extend their fixed term contract and keep them on furlough, keep them employed and apply to get 80% of their wages back. So it's going to cover a lot more fixed term workers than we all initially thought that it might. It doesn't cover self-employed or people that provide services through a limited company, but it does cover what we would call workers rather than full employees. So you'll be aware that you've got someone who's a full employee on an employment contract, and then you've got another sort of slightly lower class of employee who's known as a worker, who often will be casual, they won't have regular hours, etc. They're likely to be workers and they are going to be covered and can be furloughed too. Public sector organisations, at the start the guidance had said that you really shouldn't be looking at the scheme if you were a public sector organisation or if you got public funding to cover your employee costs. That's still the case, the guidance still says that. But it appears that the way it's being implemented is that if you're an organisation where you've got employees with a mix of public and other funding, so grant funding or commercial monies coming in, then you can look at furloughing staff that are potentially employed under a mix of public and other funding. Really, I suppose the guiding principle is if your government money is still there and it's still there to pay wages, then you shouldn't also be applying to HMRC for a grant. But if your staff costs are severely impacted by a loss of other income, commercial or grant funding, then potentially it does apply to you. So that might be one situation where I would urge you to get your own independent advice if you had a particular scenario where the funding of employee wages was a bit more complex. The scheme also doesn't cover employees who are taking unpaid leave before the 28th of February. So people that might have been off sick long term, or people on sabbaticals, they've got to stay on that unpaid leave until their return date. And if they become fit for work, or if they're back from their sabbatical, they can then be furloughed. But if they're already on unpaid long-term leave, then that's where they have to stay. Maternity and other forms of parental leave, adoption leave, shared parental, paternity leave, all of those, you can furlough people who are on that type of leave, but they retain their entitlement to their statutory pay. So they'll be technically furloughed, but they'll still get either their statutory maternity pay or their adoption pay, whatever it is that they are entitled to, and you would claim back what you would normally claim back. So 92% of statutory maternity pay would be claimed back as normal, and your furlough scheme wouldn't, although they would be technically furloughed, you wouldn't apply for 80% of their wages. However, if that person on statutory maternity pay also got the contractual enhancement on top of that, you can claim for that enhancement through the furlough scheme. So there might be a bit of a complicated calculation to be done there, but you can claim back the statutory maternity pay as you normally would, and you can also look to get 80% of your contractual enhancement back as well. What about sick employees? That's the next slide. So what the guidance says here is furlough's not intended to cover short-term absences. So if someone's off sick, you don't automatically put them on your claim and try and get 80% of their pay. However, if that person who is off sick is part of a group of people that you would have furloughed anyway, so you've got a business reason for furloughing them, they just happen to also be off sick, you can still furlough them, and you can pay them the furlough rate. So if you are agreeing to pay everybody 80%, when they're on furlough, then that sick person gets 80% like everybody else. They don't get sick pay, they get furlough pay. Or you can decide to treat them as sick and pay them statutory sick pay, but you wouldn't be able to claim that back. So really it's up to the employer to decide, this person is sick and they're not furloughed, or this person, I want to furlough this person and it just so happens that they are sick, and you can decide which way you want to go with that. Same if employees who've been furloughed then become sick, it's the same again. You either just keep them on furlough, keep claiming back 80% of their pay, or you move them on to sick pay, but then you can't claim that back unless you're a small employer and you can claim back a little bit of statutory sick pay. So really, I think it's best for employer and employee if those that are sick are just treated as furloughed and you claim back 80% of their pay, rather than switching them between sick pay and furlough pay. But as I say, it's up to the employer and what they agree with the employee. Employees who are shielding, so they might not be sick, but they may be unable to work because they have to stay at home, they're shielding in line with public health guidance, or they're self-isolating because someone else at home is sick, they can be furloughed, even if their job still exists. The fact that they can't do it would mean that they would fall within the terms of the scheme. So they can be furloughed and you can claim back for their salary too. So that's sick employees. How is the grant calculated? So that's the next slide. The key here is to work out the reference salary, and this is where I would urge you to look at the guidance. One of those pieces of guidance that was on the third slide was about how do I claim back 80% of my employees' wages. That's the one that takes you through almost step by step how you calculate your what we call the reference salary, which is the salary which you will use to calculate whatever 80% is. And the guidance takes you through some worked examples, and there's also an online calculator that you can try. I haven't tried it myself. It only applies to it really only applies to very straightforward cases, which I suppose isn't that helpful. But it might, you might be able to use it to help you calculate how you're going to go about making a claim. As it's HMRC obviously that are dealing with this, so they will retain the right to audit claims. So you are going to need to keep records of this for at least 5 years. What they've also said is if you get this wrong, then it could invalidate your claim, but that they're not going, it sounds like they're not going to be too strict. And as long as you've used a logical way of calculating it in line with the guidance, then they're not going to try and catch you out. They are going to be very vigilant in terms of potential fraud, but if you're genuinely trying to get it right, then it sounds like they are going to try and be nice. But don't sue me if that's not the case. When you're calculating the reference salary, there's a few things to bear in mind. If you have a salary sacrifice scheme, so you might agree salary sacrifice with your employees to pay their pension contributions. So the salary that you're going to be looking at under the furlough scheme is the post-sacrifice salary. So whatever the pay is after the pension payments have come off, that's the key figure there. Where you've got workers with variable pay, that can become quite complicated. You have to look at two different figures and see which one is the highest. So if you've got someone who earns different amounts every month, you look at what did they earn in March, April, May, June 2019 and compare it with the months that you're claiming for here. And you compare that with their average monthly earnings in the tax year 2019-2020. And you see which one is the highest figure, and that's the one you use to apply for 80% grant. So variable pay is a little bit tricky. The other things to bear in mind when it comes to variable pay are what variable amounts do you include. Now this is where the guidance isn't that helpful, because it uses quite strange language that HR and employment law people are not that familiar with. They talk about things like you can include non-discretionary overtime, fees and commission. Now, I've never heard of non-discretionary overtime, and I'm not sure if any of you have either. I think by that they mean contractual overtime, and we are taking that to mean that when you're calculating it, you look at what, if they've earned overtime in the relevant period, then that's included, and if they would normally have compulsory guaranteed overtime, that's included. But ad hoc, purely voluntary overtime isn't something you have to give credit for, we don't think. I think that's what they mean by non-discretionary, is compulsory or contractual overtime is included, ad hoc voluntary overtime isn't. Non-discretionary commission, we think, means contractual commission, so regular commission that you absolutely receive, and it's a large part of your salary every month, that would be included. Excluded, however, are discretionary overtime and discretionary commission, which again, discretionary overtime, we think it means purely voluntary and not guaranteed. Discretionary bonuses are not included, anything that's dependent on performance and doesn't have to be paid. So a discretionary annual bonus, for instance, wouldn't fall within the calculation here. Neither would discretionary commission that isn't regularly paid as normal pay on a contractual basis. So those elements are a little bit unclear. And again, if you've got employees where commission is a big deal or a bonus is a big deal and it's not clear, then I would advise you to take some individual advice about that. It's up to you to decide whether or not you want to pay more than the 80% that HMRC is going to give you a grant for. Certainly in my experience, a lot of employers are topping the salaries up to 100%, or they're topping up some of their higher earners who would get less than 80% because they earn more than $2,500 a month. But you won't get any of that back. It's really up to the employer to decide whether they want to top up or not. You also need to top up employer NICs on any top up of salary. Similarly, if you pay any higher pension contribution than 3%, that will have to be topped up if you decide that's what you're going to continue to pay. And again, if you're going to pay 100%, are you going to pay say your employer contribution is 10%, are you going to pay 10% on your 80% salary and 10% on your 100% salary? All of that will have to be decided and agreed with the employees, and you can only claim back 3% of that. You should also be aware that regardless, once you've agreed this change in the salary with your employees, so if you decide to pay them 80% and they agree to that, and your application to HMRC is then rejected, you are still liable, you probably are still liable to pay the employees that 80%. You can't turn around and say, oh, sorry, we didn't get the grant, so we're not paying you anything this month. You probably end up with a breach of contract claim there. So what can employees do while they're furloughed? The straightforward answer to that is, for you as an employer, absolutely nothing really. So they can't undertake any work, they mustn't provide any services or generate any revenue for you. They can volunteer, but they can't volunteer for you. They can do training, so you can give them training, as long as it's not giving you services indirectly or generating revenue for you indirectly. You can look for volunteering opportunities for your employees, you can point them in the right direction for things, but they can't be doing work or services for you. Can they work elsewhere? We did think in the early days of this that you really shouldn't be letting your employees work elsewhere in a second job, say going and working in Tesco, for instance, because that might invalidate your furlough claim if they were basically earning twice. However, the guidance does say that employees can work for another employer whilst they are furloughed. So it looks as if HMRC are not going to use that as a reason for refusing claims. However, if your employment contracts already say that they can't work anywhere else for you whilst they're employed by you, then you can continue to stop them working for other people. If you would rather they didn't take a second job, then you remind in your agreement with them to be furloughed, you remind them that they can't work elsewhere. Some employers are being more flexible about that, some are taking a harder line. It really just depends on the business concerned. In terms of giving them notice to come back, this is the other thing I think that impacts on whether they can go and work for another employer. If they go and work for another employer and you might need them back at short notice, that might make it difficult for you. I've seen a lot of employers agreeing very short notice periods with employees to come back to work. So some of the agreements will say we will give you a day or two's notice for you to come back to work, because depending on the sector, some businesses might need their employees back at very short notice. And there's no rule of thumb on that. You can agree whatever you like with the employee in terms of how much time you're going to give them to get themselves back to work once you stop furloughing them. So in terms of the process, I've said already that if we move on to the next slide, is that what process should I follow? This is very much a change to somebody's terms and conditions, so you do need to agree it with them. And depending on what your contracts of employment say, you might want to take legal advice about how you should go about agreeing that variation of their contracts. It has to be in writing, but it doesn't mean it has to be, you don't need a signed piece of paper back from your employees. Agreement by email can sometimes be enough, as long as you've got proof that you have agreed a change in your employees' contracts to pay them 80% of their wages and to be furloughed, and that what they must agree to is not undertaking any work for you in the period. And that's what you'll have to keep for 5 years and show to HMRC if they ever come and audit you. In terms of, because it's a change to terms and conditions, if sufficient numbers of staff are involved, you might need to do collective consultation if there's more than 20, and if it's likely that 20 or more people refuse to agree. Now, so far I haven't had any clients who have had employees refusing to agree, or there certainly haven't been any refusals in any significant numbers. But what you need to remember is if someone does refuse to agree and you need to dismiss and re-engage them in order to get their agreement on these new terms, then that amounts to a dismissal. and it's a dismissal that needs to be consulted on to stop that dismissal becoming unfair. So if there's less than 20 people, you would go through a process with them by saying, well, if you're not going to agree, we're going to have to terminate and re-engage your contract, and I'm going to talk to you, I'm going to discuss that with you and tell you why I'm doing it. And you'd go through a sort of brief consultation process with them. If, however, you've got more than 20 people saying, no, we don't agree, you would have to go through the process like you would in a collective redundancy situation of formal collective consultation, where you would be electing employee representatives or notifying trade union representatives. You would also have to notify the Secretary of State with an HR1 form that potentially there are 20 or more dismissals going to happen. And you would need to go, I won't go into that process right now, but that would be a whole other, it's quite an involved piece of work you would need to go through. As I say, I've not come across any, I've not come across that happening yet, because most employees seem to be fairly amenable to agreeing furlough. But again, I would, if there's a risk that you're going to have 20 or more people refusing, then I would urge you to take your own advice. And again, it's something we're very happy to give you advice on at Morton Fraser. That was the next slide. What if my employee or worker doesn't agree? And the last slide, I was just going to briefly look at how does furloughing affect annual leave. And this was something that was a bit of a vexed question until quite recently, because the guidance really didn't say anything about annual leave. And of course, we were coming up to the Easter weekend, and employers really were very unclear about how to treat the bank holidays or pre-booked holidays or holidays that were coming up. Should they be cancelled? Should they be allowed? If the holidays were allowed, what should they be paid? How did that affect what we were agreeing with employees in our furlough agreements? So we have got a bit more clarity now in terms of annual leave. So what we do know is, if you've been furloughed, your annual leave continues to accrue. You might be aware that the government, amongst all the other amendments that have been made to legislation, they've also amended the working time regulations to allow employees to carry forward annual leave for up to 2 years if they can't take it because of the coronavirus. So that covers the minimum 4 weeks European holidays. So you might be aware that you get 4 weeks annual leave under EU law, and then an extra 1.6 weeks under the working time regulations. So that gives us our 5.6 weeks minimum statutory holidays, and then some employers give more contractual holiday on top of that 5.6 weeks. What the new law says is that minimum 4 weeks, if for some reason it wasn't reasonably practicable for you to take that minimum 4 weeks because of the effects of the coronavirus, i.e. because you were ill or because you weren't able to take that holiday for some reason because you had to keep working, for instance, you are able to then carry that over for up to 2 leave years. And then it's now up to employers to decide, do we allow carryover for the 1.6 weeks in addition to that, and any contractual holiday on top of that. So what employers, I think, are trying to avoid are people saving up huge amounts of leave and not taking any, and then them coming back from furlough, and then you've got a lot of employees with accrued holiday entitlement that needs to be taken. So for that reason, employers are asking, well, if annual leave is accruing during furlough and we've got this 2-year carryover for a bulk of it, can we ask employees to take their annual leave while they're on furlough? Or if they've already got it booked, can we insist that they take it? So the answer to that is yes, you can. As long as you're not breaking the 3-week period. You remember they have to be off on furlough for at least 3 weeks. So you don't want annual leave. You want to be clear that they're on furlough leave. If they're also taking annual leave at the same time, you need to pay them 100% of their normal salary. You do your normal holiday pay calculation, albeit that you would claim 80% of the reference salary back under your claim. You can also compel employees to take holiday whilst they're furloughed, Although I would urge caution with that. You do have to give them sufficient notice, so that the notice period will be double the length of the period of the annual leave. So if you want someone to take 2 weeks annual leave whilst they're furloughed, you need to give them 4 weeks notice to take that 2 weeks leave. If what you're trying to do is exhaust their annual leave before they come back from furlough, you might end up on the wrong end of a constructive dismissal claim. But if what you're trying to do is just manage in a reasonable way your annual leave and your holiday year, then you should be okay as long as you're giving sufficient notice. Bank holidays, we've obviously just had 2 bank holidays. If staff were on furlough then they can be treated as having been on holiday and used those bank holidays, and they would have to have been paid 100% normal pay for those bank holidays, unless you then agree that actually, okay, we'll agree that wasn't a holiday day and we'll give you that day back in lieu at another time. So you can make that a subject of an individual agreement with your employees depending on how you wanted to treat those bank holidays. Okay, so that's a bit of a whiz through. Kieran, I'm not sure if there are many questions coming through. I'm very happy to take any just now.
There are a few questions coming through. So one has come through. I think you've covered some of it. It's on from someone saying if they have a staff member who's been furloughed, can they do any work for another colleague within the same organisation? In that case, that would be still doing work for the organisation.
Yeah, absolutely. Yeah.
Absolutely. Yeah, and we're quite clear because within the sector there's a lot of people asking about whether you can volunteer for the same organisation that's still providing a service, so therefore you cannot do that. That's what.
I mean, it does seem crazy. It seems crazy that they could go to another charity or another third sector body and volunteer for them, but not for you. But that's the way it is, and that is the one thing that all the guidance is really strong on, is you must not do anything for your employer at all. So you need to be really careful about that.
Beforehand as well, the last time we looked at this, the guidance said that they didn't expect that if someone was a public sector worker, the language round about that was still a little bit ambiguous. Is there anything which is kind of more concrete? If you basically get funding from a public body, i.e. like a lot of organisations, is it any clearer whether you can be furloughed?
I think it comes down to the individuals concerned. So if you've got staff that are purely publicly funded and you're still getting that public funding for that person, you shouldn't be furloughing them. But if you've got someone that's on a mix and it looks like part of that mix is at risk because of the current crisis, then you can probably furlough them. There is some guidance from the Department for Education if anyone's involved in education, and it probably helps third sector organisations as well, where it talks about say you get a certain percentage of money for a team or a contract, then you can say you've got 10 staff, and of those 10 staff 20% is 20% of the money for those 10 staff comes from the non-public sector, then you could furlough 20% of the 10 people. So that's what the education guidance from the Department for Education says about organisations that get money from them. Okay. So you could kind of apply the same logic, because I'm conscious that a lot of organisations can't just point to Mr. X and say, yeah, Mr. X is on a mixture of this, that, and the next thing. But you might have a team that get a percentage of public funding, and what the education guidance seems to say is that if that team is 20% funded by commercial, then you can furlough 20% of that team.
That makes sense. Yeah, someone's going to.
Yeah, but that, as I say, that's quite specific guidance coming from the Department for Education in England about how they are looking at it. So it's a bit of a tricky one.
Tricky one to navigate. Just some additional information which we found within the HMRC's website before we move on to the next session. It opens on the 1st of March, as you said, and it'll stay open until at least for 4 months, so until July. And you can, as you've mentioned, you can claim backdated to the 1st of March 2020. Employers will receive payment within 6 working days from making a claim, so that's on the HMRC website. The information that you'll need to make a claim, so have this information prepared before you go onto the website: your employer PAYE reference number, the number of employees being furloughed, furloughed employees' national insurance numbers, names of the furloughed workers and their PAYE numbers, your self-assessment unique tax reference number, your corporation tax reference, your company reference number, or employee name as appropriate to you. You should put in your claim period, so the start and end date of the claim, and you should also have your bank account number and your sort code. So have all of that information ready before you make a claim on the system. Within your website, in the Learning Hub, within the page for the furloughing section, we've actually added some guidance there from the job retention schemes. Follow that advice when you're making a payment. And we also have included a template ACAS letter that you can use to issue to employees also. So that's on our website. Perfect. Okay. So thank you very much, Sarah. That's been fantastic. That's great. Thanks for doing it again a second time. And,
you're welcome.
Just to say that again, we will have details of Morton Fraser and yourself on the website to refer onto. Thanks, Sarah.
Okay.
Thank you very much.
Bye-bye.
Bye. Fantastic. Okay, so I'll just pull up the slides for Scott and for Kirsty.